Emerging and Dynamic Trust Laws, a New Wealth Management Paradigm, was a live webinar that was originally produced on Wednesday, November 16th, 2016. The presenters for this presentation were David Warren and Jessica Beavers, both with Bridgeford Trust Company. Enjoy this webinar recap and visit us online at www.macpas.com for more information about our future events and presentations.
Hey, thanks, Tyler. It's great to be here with you and have the opportunity to talk about some really exciting things happening in trust law around the country. Actually happy to see so many friends from around the country and the world joining us. We have people from Naples and a friend from Germany and some people from New York City, and we're really happy to have you here. Please ask us questions. It's pretty easy to do. You just type in the question. We want to make this as interactive as we possibly can, because really we're going to talk about some pretty exciting and dynamic topics today. And two in particular very, very exciting new trust laws that are having a huge impact on trust planning. As we began Bridgeford years ago, one of the most important aspects of Bridgeford was selecting what we believe to be the best jurisdiction, trust jurisdiction, because jurisdiction has become to be so important in the trust planning process. And in fact, as we were doing our research, we came across a quote that really guides us and guides so many of our planners around the country and the world. And I think it's aptly said by Elizabeth that the choice of a state in which to establish a trust is as critical as a decision to create one. And I think that's more true now, today, than ever, as we're seeing more and more international families come to the United States, more and more domestic families and their advisors looking very, very hard at trust planning options in progressive trust jurisdictions. And as we've noticed over the years, and as we certainly figured out years ago as we were deciding which state we wanted to be in as a trust company, there's a fascinating race happening around the country as to which state can be the best trust jurisdiction, meaning which state can establish laws that are not only the most progressive, but also the most flexible and give the most control to advisors and people who are settling trusts and future and current beneficiaries. And really, there have been 4 states that have risen to the top. I think there's general consensus among many of the experts, particularly Trust and Estates magazine, that consider South Dakota, Delaware, Nevada, and Alaska to be the top-tier trust jurisdictions. And not only is that just a domestic reality, but also around the world, people have come to believe that those are the top trust jurisdictions in terms of the planning options that are available. And we're going to talk about that, and we're going to talk about areas that are looked at to determine which is the best trust jurisdiction. The purpose of today is not to argue that necessarily one of the 4 is better than the other. The purpose today is to focus on some really exciting trust laws that are extraordinarily compelling in the planning process, and examine some of the areas that are looked to by practitioners and advisors as to why one state might be better than the other. But it's in the context of particular planning options. Particularly, we're going to hit on asset protection a little bit, Dynasty trust, do some definitional discussion around that. Taxation, which is pretty powerful now in a way that maybe it wasn't a couple years ago, and really is perhaps the most directly measurable aspect of selecting the proper trust jurisdiction, not only domestically but internationally. And also, we're going to look at privacy rules. That is a hot area right now. And then generally modern trust laws, which is where we're going to focus on some of the new laws that have emerged. And I think that what we want to accomplish at the end of the hour is to convey that this is a quickly dynamic and fluid area where knowing where to go and where you can avail your clients and yourselves of the best possible trust jurisdiction tools, or the best trust planning tools, rather, is vitally important. So again, we want for there to be as much participation as possible. We encourage questions. And with that, we'd like to get into a discussion quickly of a domestic asset protection trust. The idea of a domestic asset protection trust has been with us now for 15 or 20 years. And has become unequivocally a powerful planning tool in the United States, and in fact has gotten a lot of interest around the world as well here in the United States. And what's so amazing about it is the fact, and what's so different about the asset protection trust is that it's self-settled. Jessica, can you talk to us a little bit about why that makes it different and why that matters overall relative to control and the ability to be flexible?
Yeah, of course. A self-settled trust is one of the more frequently used types of domestic asset protection trust that we see utilized in South Dakota. It's generally a discretionary, irrevocable trust where the grantor or the settler is a permissible beneficiary. If it's properly structured and administered, creditors cannot generally reach the assets in the self-settled trust to satisfy the settler's legal obligations. Now, currently, we are aware of only 15 states, including South Dakota, that have self-settled domestic asset protection statutes. South Dakota enacted our statutes in 2005. When we talk about a self-settled trust, what are the requirements, or what do we see that needs to happen before we can have one of these trusts in place? We get a little granular here when we talk about there cannot be a pre-existing understanding or arrangement between the settler and a trustee. We have to make sure that creditors of the settler are unable to access the trust property as defined by state law. We need to ensure that the assets were not transferred fraudulently, and we need to make sure that notice is given to the transfer spouse if there's marital property that is transferred after a marriage. So, furthermore, most states provide exceptions for certain creditors, which now we get into something called an exception creditor. So, for example, Delaware would permit child support, alimony, and maintenance. Nevada permits a creditor to reach trust assets where a transfer violates legal obligation under contract or valid court order. South Dakota permits reaching trust assets for child support, alimony maintenance, and distributions of property due to a divorce.
Excellent. And I think that one of the aspects that we wanted to touch on with domestic asset protection, and it's honestly a theme that you're going to hear throughout the hour, is that what makes this trust so unusual is that it's self-settled, as Jessica talked about, which means that the settler can enjoy income, the settler can have discretionary distributions, and the settler can exercise a lot more control over this irrevocable trust in ways that was never really the case before the establishment of this trust. So as a vehicle, generally speaking, it is something that is very, very, very progressive in the United States and works exceedingly well because, it gives so much more control and flexibility while giving pretty powerful asset protection capabilities. I mean, just a couple of points. One is, the fraudulent conveyance statute is what Jessica has referenced, and it's vitally important that there isn't a pending claim that would be that the settler knows about. So, for example, if Tyler wants to set up an asset protection trust and he has general concerns of being in a heightened liability profession, or has activity that would expose him to heightened liability, that's fine. If Tyler comes to Bridgeford and says, look, I just got sued, I need to establish an asset protection trust, that is not okay, and that's called a fraudulent conveyance, or it's a fancy way of saying look back. When we compare these states, it's very, very important. Just because a state has a domestic asset protection statute doesn't mean it's the best. Or maybe the best answer. And so that's why jurisdiction selection is so important. You see on the screen, the look-back period is important, as I just described it. It's 2 years in South Dakota, and in Delaware it's 4 years. That is important. Why? Because if you have somebody who's in a heightened sense of liability or worried about liability, particularly a physician or a construction owner of a construction company where we typically see it, if they can get liability if they can get asset protection to attach 2 years instead of 4 years, that's powerful. That is why so many of these trusts are going in the states that have a shorter look-back period, and I think it's important to make these distinctions. The final point I wanted to quickly make about the Domestic Asset Protection Trust, and again, we encourage any questions about this, is they're highly debated, and there are practitioners in the United States who argue that these are not effective, and that's an interesting discussion point, and one that probably is yet unresolved. I mean, the reality today, and it's unequivocal, today there's not a single case that has otherwise pierced or shot down a domestic asset protection statute because of the statute itself being inappropriate or being inapplicable. Every case that has been brought that you've read about or have seen, it has to do with some aspect of a fraudulent conveyance. We're all aware of a case up in the Northwest that talks about whether or not an asset protection trust would work, but the court didn't rule on that question. The court ruled on the fact that it's a fraudulent conveyance. So regardless of where the debate falls, today there's nothing in the U.S. trust law that definitively says that domestic asset protection does not work. And I think it's important to make that distinction up front. Which leads us to the Dynasty Trust. Which is probably where modern trust law began. Would you agree with that, Jessica?
I would. We say that this is South Dakota's claim to fame, is when in 1983 we abolished the rule against perpetuity by statutes. This is where really we say that it all started, and this is really what makes the difference in how we look at various trusts for dynasty planning purposes.
Absolutely, and I think it's one of the sort of cornerstones which will lead us into different conversations about trust taxation. But generally speaking, this rule against perpetuities was an arcane rule that came from England, and it's driven by state law. And really, what it says is a trust has to end at some point. And we're not going to get into the details because, frankly, most lawyers and those of us don't even really understand how the rule against perpetuities works in actuality. But the reality is it is supposed to mean a trust ends at some point, which means it is subject to federal taxation. Well, the Dynasty Trust lives forever, meaning it never has to end, which is where this perpetuities piece goes away. And it has become an extremely important planning tool. And I say it's the beginning of modern trust law because I think that is the first change that happened at South Dakota that really kicked off this race that happened. So what you find is some states have abolished it altogether, like South Dakota. Most states, like Nevada, have not abolished it, but have amended it somehow in a way to make it longer. So I think Nevada's is 365 years. And so why is that important? There's a very interesting constitutional issue that was raised at Heckerling, with the premier Trust and Estates conference down in Orlando. And it's really interesting to make this point, and we don't want to belabor it, but it's something to think about. There was a question that was raised in Trust and Estates magazine and others that said, some state constitutions prohibit amending or otherwise prohibiting, or not prohibiting, abolishing the rule against perpetuities. So, in other words, states like particularly Nevada have modified their rule against perpetuities, but it's been observed that was in direct violation of their state constitution. Whereas in South Dakota, there was no constitutional limitation on that. So again, why do we care? Is it just a myopic area of law that's fun to talk about at high-end conferences? No. Here's why it's important. If in fact a state constitution prohibits tampering with, for lack of a better way of saying it, the rule against perpetuities, an argument can be made that all of these dynasty trusts in those jurisdictions are unconstitutional from a state perspective and not enforceable. And so we haven't gotten there yet. I'm interested in this issue and where it goes and whether these states are going to either amend their constitutions or figure out a way to address it. But it's an issue that, while not talked about in any of the literature currently, is still out there, and I think has driven frankly, a lot of people to South Dakota because it's pretty definitive as to the fact that it's not unconstitutional. I didn't mean to use a double negative, but it's considered to be appropriate under the Constitution. And the other important point to make is the fact that not all dynasty trusts are considered or created equally. Jessica, what are we looking at here?
This would be a chart that is put together. We see several of these, but I don't know if you've seen these charts by Steve Oceans. He's an attorney out of Nevada that puts together these charts, and it's showing that South Dakota has a #1 ranking when it comes to dynasty trust planning. You know, the dynasty trust planning, when we put the statute in place in South Dakota in 1983, what happened was we codified the 1979 Murphy case that the IRS acquiesced to the method utilized to abolish that rule against perpetuities. And that Murphy case approach, which abolishes the rule against perpetuities, shifts the perpetuities inquiry from remoteness of vesting to suspension to the power of alienation. And so, for example, if the trustee has an explicit or implied power to sell, the trust jumps outside the rule of suspension of alienation, which limits the duration of trust. So that's really the technicality behind all of this. And generally, states that have embraced the Murphy case have done away with the rule against perpetuities. And when you look at generation skipping tax experts and rule against perpetuity experts, they are hanging their hats on South Dakota. And that's what you're seeing here with this #1 ranking.
Absolutely. I think that what this chart does, and as Jessica explained, I mean, there's a technical aspects to why this works, but then when we look at the practical application, you know, the reality is this Nevada attorney does a great job of putting together rubrics and schematics like this to show, you know, why one state may be considered stronger than the other. And it's objective. It's not subjective, and I think we like to rely on this as a matter of fact. So it looks at whether or not a state has an income tax, which we're going to talk about in a second. It talks about whether they have a domestic asset protection statute, and it ranks them, as you can see. And I think what's probably most interesting isn't so much that South Dakota and Nevada are at the top. I think what's most interesting, in my opinion, is the fact that Delaware has sort of fallen down the list to #7. You know, the reality is, and when I had practiced law, Delaware was this sort of shining example of a state to go to for all things related to progressive trust planning. And it still is a very good state, but the reality is Delaware just isn't keeping up. And that's not just the opinion of David Warren or Jessica Beavers or Bridgewater Trust Company. That's the opinion of people, frankly, far smarter than I am, who are evaluating these areas of law that we're going to talk about. And they're saying, look, Delaware just isn't the progressive state it used to be. Again, it's a good state, and I'm not going to suggest that if you're there, you've made a mistake, but you're going to hear, as we talk about, there's some progressive, very modern trust laws that are coming onto the books here that Delaware isn't embracing yet. And they may well embrace it, but I think it's important to understand the landscape is quickly changing, and as advisors, we need to know that. Would you agree with that, Jessica?
I would. And, you know, when you take a look at the order of events here, we abolished this in 1983. That is pre the generation skipping tax of 1986. When we look at Delaware did away with their rule in 1995 in response to South Dakota and the business that it was generating. So I think there are a lot of other states that have done other things to stay on top or to crawl to the top. But the bottom line is this was done in South Dakota before the GST tax was even in place in 1986, which makes it that much stronger.
Well, that's a great point. So one of the areas that you see on the chart up here is whether a state tax has a state income tax. And that is an area of comparison, an area of trust law that is, as I've said earlier, I believe, and I think generally people believe, is the most absolute measurable aspect of any trust planning. at the end of the day, we can talk about, well, maybe you should do an asset protection trust, or, these dynasty trusts are great, and it's probably a good benefit over the course of 500 years, sure. But trust taxation is something we can measure right now, and I think really separates the planning community. Meaning, you can have a planner who forgets to mention this, or maybe doesn't know a lot about it, that could actually have dire consequences for a trust. And so, this is an exciting area for us, and I just we wanted to spend just a little bit of time on making some distinctions. The top tier trust jurisdictions that we talked about are top tier because all four of them do not have an income tax. So really practically, what does that mean? Each state can make their own rules and their own laws, as we've talked about, and that applies to how trusts are taxed. And so if a state doesn't have an income tax, then an argument can be made, and I'm going to show you a case law that supports it, that in fact undistributed income in a trust that's has proper jurisdiction in a state like South Dakota or Delaware or Nevada or Alaska, if it's properly situs there, meaning administration happens there and all the appropriate prerequisites to make it properly in that state, if everything is done correctly, it falls under the jurisdiction of one of those states, and a state where the beneficiary lives or where the settler lives should not be able to tax the undistributed income. And it's important to make that distinction. Not income that's distributed to a beneficiary. We all know that's going to be taxed at ordinary income. Can't avoid that, and we shouldn't avoid it. But the tax itself. So where does that become important? When we have these dynasty trusts that can live forever, when we have planning that's talking about multiple generation of planning, often we have trusts that don't distribute much income because they're meant for future generations. And so in a state like Pennsylvania, where there's a little over 3% tax, sure, that's a big deal, I suppose, if you have a $100 million trust over 4, 5, 10, 20 years. Yeah, that adds up. But when we're talking about states like New Jersey or North Carolina or California, now we're talking about some huge potential tax savings, and it's very simple. It's very simple. It's a matter of just selecting the proper trust jurisdiction. And so just to define some of these terms, a resident trust is a trust where situs and trust jurisdiction is in a jurisdiction other than where the settler, beneficiaries, or co-trustees reside. I've already said that, but I put a definition around it. That's a resident trust. So, for example, Tyler is a Pennsylvania resident, establishes a trust in South Dakota or Delaware. It's properly set up and it's properly administered. The argument is that is a Delaware-governed legal entity and should not be subjected to Pennsylvania taxation. So we'll hold on to that point for a second. Sourced versus non-sourced. It's an important distinction under the case law. Sourced is any income, as most of you know, income that's generated within the state. So Tyler puts into the trust interest that he has in his closely held business that generates $1 million a year in Pennsylvania. Sourced business in Pennsylvania. That is still considered available for taxation in Pennsylvania. That makes sense. That's consistent with case law and codified law around the country. Non-sourced, though, income is really the interesting where sort of the rubber hits the road here. Non-sourced income, like income generated from investment management accounts, which make up the bulk of lots of folks' trust assets around the country and the world, that's considered non-sourced. The case law has been consistent, saying that an investment account at Merrill Lynch or Morgan Stanley, the interest that's generated within that trust that's undistributed is considered non-sourced to that particular state, and therefore unable to be taxed. And what's most exciting, in my view, and it sounds like I'm being a bit of a nerd here, but what's most exciting is how this becomes practical. Case law across the country is supporting this, and here's what's really interesting about it. Pennsylvania was one of the first states not the first state, but one of the first states in the country to look at this issue and actually hold that it was unconstitutional for the state of Pennsylvania to tax a resident trust, as we've defined, a trust that's properly in another state and properly administered. And it was unconstitutional for two reasons: a violation of the Commerce Clause and a violation of due process. So those of us who had, on the call who went to law school and had constitutional law, we would say, well, yeah, that makes perfect sense. Why should one state be able to tax a legal entity of another state if there's not appropriate nexus? So it's all common sense. But what's so great about it is now we have case law that we can rely upon. There's a case in New Jersey that's almost exactly the same fact pattern, holds the same conclusion for the same reasons, and there's a case in North Carolina. And all of these cases are at the appellate court level, I should say. So we're not talking about a trial court level case. None of these cases have been appealed to the Supreme Court in each of these, the state Supreme Court, which means that each of the taxing authorities have accepted these rulings and are making this as part of their instructions as to how to handle trust tax returns. And so this is again an exciting development in our view of what's happening in the trust world and why jurisdiction matters. I mean, this is probably no more clear than in this particular conversation. It's a compelling tax planning opportunity. And Jessica, I mean, I think that, from our perspective, we're seeing a lot of activity of folks leaving states like Pennsylvania, New Jersey, in North Dakota, North Carolina and California. And that's been our experience. You want to talk a little bit more about that?
It's definitely been our experience. Being on the administrative side, I like to tell stories, and I can tell you of a client that we had that was, the client was from Illinois. The client owned an island off the coast of Florida and was going to sell this island that had a very low cost basis. And so what the client did was put the island in the trust, which was an Illinois trust, moved the trust to South Dakota, and then decanted, and we'll talk about this concept in a moment here, but decanted just that one particular asset into another trust, and then went ahead and sold the island. And guess what? South Dakota has zero capital gains at a state tax level. We can't do anything at a federal tax level, but at a state tax level, the client just saved the state income tax that would have been paid to the state of Illinois through the planning that his advisor had done for him. So that's the reality, and those are the types of clients that are coming to us for a variety of tax reasons.
Thanks, Jessica. I mean, absolutely. So again, this is a compelling tax planning opportunity that's directly measurable. And I always talk about it in the context of if we have a client that's at the country club and is in South Dakota or Delaware and has had the ability to avoid significant state taxation and talks to another client with similar asset base and finds out, that client finds out his attorney didn't mention this or his accountant or his other professionals, is that a malpractice question? I don't know. I think it's a fair question to ask. But the reality is these are real planning opportunities and ones that really just can't be ignored. And it has a huge substantial impact on the total value of the trust over generations. Remember, when we talk about a dynasty trust that theoretically can live forever, we're talking about the ability to do and shield the trust from some amazing taxation, which leads us to really the first of two brand new trust laws that we're excited to talk to you about. And there are people on this call that I know I've talked about it with, and it's sparked a lot of excitement. And we're going to just go through it a little bit because it's the reason why it's so brand new right now is the fact that South Dakota just passed a version of the South Dakota Community Property Spousal Trust or the Community Property Trust that is very powerful. And can, in addition to the tax savings that we've talked about, adds a whole nother level of potential and extremely compelling tax savings relative to community property. Very simply stated, we have spouses that hold property independently, or rather jointly, which we all have clients like that. They have the ability to put these assets in a South Dakota Community Property Trust and enjoy a 100% step up in basis at the death of the first spouse. So I'll say that again because it's pretty powerful. A 100% step up in basis, unlike what you traditionally see in a community property state of 50% step up in basis. So what does that mean? if we have a trust that can avoid substantial capital gains on low cost basis property, whatever the property is, and then it's subsequently sold at the death of the first person, we've avoided all of those capital gains, while at the same time potentially avoiding federal taxation forever, because these can be also a dynasty trust. So we've avoided two areas of what could be pretty painful taxation on trust assets. And then we throw on top of that the third aspect of this, which we just described, which is the ability to avoid taxation on the undistributed income within a trust. So if we add all of those benefits up, we're talking about the ability to combine a dynasty trust to avoid income tax, to avoid capital gains tax, all because we chose the correct jurisdiction. All because we realized that maybe Pennsylvania wasn't the best place to be. Maybe California. Well, we all know California is probably the worst place to be. No offense to our California friends on the call, but the reality is this is the importance of how this works. A couple caveats. Right now, there's a PLR pending I know of that examines the very real question as to how these trusts will be dealt with in non-community property states. For example, you take a state like Pennsylvania, which is not a community property state. Can a Pennsylvania resident establish a community property trust in South Dakota? And will that be acknowledged as the law that governs, that is to say South Dakota, for purposes of the 100% step-up in basis, although the property came from a non-community property state? We expect a positive answer. Obviously, we can't predict, and we also understand that a private letter ruling isn't law necessarily that we can rely on. But these are the cutting-edge issues that we're looking at Bridgeford, that our advisors that we work with around the country and the world are looking at. And this is exciting. And Jessica, if you can, could you juxtapose this for us relative to the community property statute in Alaska and why that has fallen out of favor? Because that's very, very important, and why this particular law is so exciting right now.
Yeah, I think that you might be referring to the economics of South Dakota,
Yep.
Of Alaska, and what's going on with oil there, and what's going on in their legislature, and just the state of the economy in Alaska is just making this not a favorable place to be. There's just a lot of uncertainty there at this time.
Well, and in fact, hasn't the governor proposed legislation to start taxing or putting taxes in place in Alaska?
Yes, I believe there was a legislative bill in 2015, I believe there was.
Yep.
Great. And just to interrupt you guys really quickly, we did have a question that came in, and I feel like this would be a good time for you guys to answer this. So here's the question. U.S. President-elect Donald Trump has tax policies that would provide large tax cuts for the wealthy. How do his proposed tax policies impact trust taxation?
Well, I'll jump in first, and Jessica, I'd love for you to offer your thoughts. I mean, I think just generally, with all due respect to the President-elect, he's said a lot of things over the last 18 months, and so I think we're not always sure what is going to actually happen based on what he's promising. First of all. Second of all, he's not yet the president, and I think it's going to be hard to see exactly what is going to happen. And although he may have a tax plan, it still has to go through Congress. We don't know what that tax plan is ultimately going to look like. I mean, there's so much uncertainty that while we're talking about some significant taxation that could really benefit some folks, I don't think it should change planning today at all. I think we have no idea what it's going to look like, and even if there are changes that have an impact on some of this planning, we won't see them for many, many months and even maybe years. And again, Congress has to agree. This isn't anything that can happen unilaterally. Jessica, what are your thoughts on that question?
Mm-hmm. I think that our clients, it used to be, because I've been in this business for a long time, that they would come for the tax environment. But more so, we see clients coming for what we're going to talk about next, which was the perfect leadway, David, into our next topics. Our clients want flexibility. They want control. They want privacy. They want to know that their heirs are going to be taken care of in a manner that they've set forth. So I think it's more than taxes, and we don't think that this will have an effect on us if there are changes. It has not slowed. It has not slowed anything down at this point.
Oh, I agree. That's well said, Jessica. Which is a great transition. You know, one of the biggest aspects of planning now more than ever is this idea of privacy. And I want to make a very stark distinction between privacy and secrecy. We're not talking about secrecy here. We're talking about privacy. Secrecy is what you would hear out of Switzerland and maybe out of some of the offshore trust jurisdictions where they're actively trying to hide nefarious or bad activity. And again, that's extremely distinguishable from privacy. And in the United States, there happens to be a state that has been considered to have the most powerful privacy provisions in not only the country, but even now it's considered to be around the world to be the most powerful privacy provisions. And so we want to talk a little bit about this because often folks don't realize how powerful that is and how much, particularly in today's environment, why it matters so much. And it's broken down into really two areas: the ability to have a quiet trust and the ability to keep information out of the public domain. Jessica, could you talk about the quiet trust for us?
Yeah, many of the families that are coming to us do not want their trust beneficiaries to know about the existence of a trust or trust assets. And so consequently, many state statutes allow the grantor to modify notice requirements in order to waive notice to beneficiaries. Now, for example, Alaska allows a grantor to exempt the trustee from the notice requirements, but only for the life of the grantor or until the grantor's incapacity, whichever is shorter. South Dakota, however, allows for a beneficiary waiver of notice. And so while also providing the grantor, the trust advisor, or a trust protector by the terms of the trust document, we can expand, restrict, eliminate, or otherwise modify the rights of the beneficiary to information. Delaware is also not as broad as allowing the trust advisor or the trust protector to modify notice to beneficiaries. So we have clients that come specifically for the quiet statutes. They don't want their children to know their worth, or they're trying to protect some class of beneficiaries until such time. And the power resides typically with a trust protector, which we're also going to talk about. But the point is, if a client, if this is a trigger for him, it's available in South Dakota.
Right. So thank you. That's excellent. And I think one of the things we see in the planning process is, and we just had this conversation yesterday with one of our clients, you know, for a settler of a trust to be able to tell Bridgeford essentially, or to tell their trust company, look, do not tell my son or daughter when they turn 18 that they're the beneficiary of a $100 million trust. That they like that control because, frankly, you know, that does change mindset. And if somebody told me I was a beneficiary of a $100 million trust, which I've been wishing for now for 43 years, you know, it would change the way I approach my life. I mean, that's unequivocal. So this quiet trust is powerful and is driving so much activity to South Dakota. But also, so is the court seal. You know, simply stated, when there's a lawsuit brought against a trust, whether it's a challenge for any reason, that information becomes a matter of public record. And you might say, well, Dave, what information are you talking about? Talking about the name of the settler, the name of the how much is in the trust, who the beneficiaries are. All of that can become part of the public domain because it gets entered into a docket, and they can search through virtue of really, especially now, online tools. And so that is a very big concern to families, not only in the United States, but around the world. They want to be able to control who gets the information with respect to beneficiaries, but they also want to control and make sure that their information never finds its way into the public domain. And interestingly, South Dakota is the only state in the country that has a total seal on this information forever. And it's also important to make the distinction that, unlike Delaware, it's not up to the court. It's not up to the judge. In Delaware, you have to go to a court, you have to ask a judge to seal the record, and you have to give him reasons. And my understanding is that the judge doesn't always give a seal. You have to give him some good reasons to do. He or she some reasons to do so. And so in South Dakota, go ahead, Jessica. Yep.
I would add that became effective just July 1 of this year, that South Dakota has this automatic seal for privacy of any petition in a court proceeding that involves a trust.
So that's powerful because we don't have to ask anybody for permission to protect this information. And more importantly, as you see in the slide, South Dakota seals only 3 years. And then after that, it becomes open to the public. So again, this is a very, very important area for planners. This is distinguishable from secrecy, which is important to continue to make that point because we're not attracting and we don't want to attract people to the United States or into progressive trust jurisdictions who are trying to hide any nefarious activity. But their right to privacy is something that South Dakota absolutely upholds, and it's something that we're excited about and to talk about. So we're going to transition into what I believe to be probably the most exciting aspect of what's happening in the trust world right now. And we've talked about some really neat concepts. I mean, the asset protection trust, very powerful. The taxation piece of it, absolutely measurable and something that is vitally important. Privacy. But now we're going to get into some areas of modern trust laws that didn't exist when I was in law school back in the mid-'90s. Laws that are so sort of new on the books that it's changed the absolute trajectory of how we plan and how we do trust planning for families. It's challenged fundamental notions of what is an irrevocable trust. You're gonna realize that these modern trust laws, in conjunction with some of the concepts we've already talked about, have radically changed what an irrevocable trust means today. These laws and what we've talked about so far are delivering so much more control back to settlers of trusts, beneficiaries, their advisors than ever before. And these positions and these concepts and these planning tools are very, very real. We see them all the time in our trust documents, and it's something that I think, again, has changed the industry in such a powerful way. And one of the areas that I'm really most excited about, and I think is a primary foundation of what we've seen in terms of modern trust law, is the idea of the directed trust. There's only a handful of states that have a directed trust. It essentially bifurcates liability, which is a big fancy way of saying it splits apart legally the role of a trust company and an investment manager, and it creates a legal framework, not a theoretical framework, but an absolute, real, practical framework that allows trustees and beneficiaries to choose who they can work with in terms of asset management and independent trust company. No longer are these functions bundled together, like at a bank in New York Mellon or a PNC or a Wells Fargo. That model of bundling together trust services, including private banking and all of the things that those big banks want to be for their clients, is, in my opinion, and the opinion of people far smarter than me, dying. And it's being replaced by the control that directed trusts give and the flexibility. And I am going to ask Jessica to talk about it in a little more detail using this chart.
Yeah, the bottom line is that our clients want flexibility and they want control. They want control of asset allocation, diversification, investment management, and distributions. And so what South Dakota has done is we have directed statutes. Most states have, like David had mentioned, delegated statutes, but South Dakota has one of the oldest and highest rated directed statutes. And this picture here shows what that means. We have bifurcated or trifurcated, if you will, the fiduciary role. Typically, there are three functions within a trustee. You have the distribution committee, which is the fiduciary responsible for making decisions on discretionary distributions. You have the investment committee that is responsible, and they're a fiduciary responsible for all of the assets that are in the trust, the asset allocation, holding closely held assets, selling assets. And then you have the administrative trustee, and I like to refer to the administrative trustee as the record keeper of all of this, and that's typically where Bridgeford serves. And then you would see family members or close family advisors serving in those other roles. And just to be clear here, these are all fiduciary roles. There's 3 silos of fiduciaries that are now involved. And the beauty of what we have done or carved out in South Dakota is that each of us is an excluded fiduciary as codified under South Dakota law, meaning as administrative trustee, Bridgeford would take direction for distributions or for investments from one of the other 2 fiduciaries, and we would be excluded from taking those directions from those other fiduciaries, as would they be excluded for our actions. So it's this extra layer of protection, if you will. But as an administrative trustee, we are now no longer responsible for making the decision to hold that LLC or to hold that closely held company or an asset that may be a concentration in the trust. And so this gives clients the flexibility that they want. They want to know who's going to be making the decisions for distribution. Somebody sitting in South Dakota, or is it trusted family advisors? Who's going to be making the decisions for investments? Is it possibly the client themselves or a committee of family members? Or is it somebody that they don't know, some great big bank? And so you can see what we have given back to the client is the flexibility and the control that they seek in a directed trust structure.
Well, and I believe it's radically changed the whole trust landscape and trust planning landscape, and it opens the door to a company like Bridgeford to feel comfortable holding non-traditional assets like insurance, art, closely held interest in a business. The traditional trust companies don't want to touch any of that, mostly because they don't make enough money off of it, primarily, quite honestly, because they want to be asset managers. But from our perspective, if liability is bifurcated, we're happy to work in that space, and it's very exciting. And we're excited about it and be able to use it. And what works in conjunction with, it's a separate statute, but what works in conjunction with the directed trust statute is in another area of modern trust law that provides tremendous control. There's this idea of a trust protector. And Jessica, could you sort of sketch that out and why we call it a super trustee?
Yeah, I like to think of the trust protectors. If you go back to that picture where we kind of separated all of the trustees, I like to say that the trust protector is really the umbrella over all of that. Previously, the concept came from offshore trusts, and the use of trust protectors domestically has been gaining popularity. South Dakota put our statute in place in 1997, and the typical purpose of a trust protector is to provide flexibility to an irrevocable trust. And so advisors are drafting trust protector functions so that clients have even more control, if you will. In South Dakota, the trust protector can have the ability to replace other trustees. The trust protector can veto any direction that comes from the distribution fiduciary or the investment fiduciary. Tyler, if you pop back to that picture where it's where we've bifurcated the role, you can see the power. Yeah, this picture here, you can see the trust protector actually can veto that distribution committee. So he can veto that fiduciary. He can veto an investment fiduciary. The trust protector has the power and the right to exercise the ability to amend the trust document, actually the power to terminate a trust document, the power to approve trust accountings, and the list goes on and on. So you can see that the trust protector has been codified under South Dakota law, and it's a very, very powerful super trustee power that we put, that most of our clients like the ability to have in their trust documents to provide maximum flexibility. It's kind of a checks and balance.
And we love it. I mean, we're not afraid of it. We embrace it, and in fact, I think in many respects, we would like to see it. We don't shy away from it at all. South Dakota has hands down the most progressive and liberal, for lack of a better word. I guess I shouldn't say that right now, coming out of election season. But it is the most progressive. Pennsylvania and other states have trust protector statutes that are less broad, but still good. I think that it's just a matter of looking for this particular powers that you want. We want to quickly sort of transition into another brand new area of trust law, something only available in South Dakota. This is something that we're particularly excited about because no other state has this. And we refer to it as the Trust Protector Light. Jessica, why don't we kind of quickly go through what that is and how that differs a bit from the Trust Protector role?
Yeah, the Trust Protector can be a fiduciary or non-fiduciary depending on the power that you're giving the Trust Protector in South Dakota. The Family Advisor, however, is a non-fiduciary role. This is new to South Dakota, again, as of July 1 of this past year, and we are not aware of any other state that has such a position. The Family Advisor was set up for clients who want their centers of influences to stay close to them. There's TPAs, their attorneys, their investment advisors. But those advisors do not want to serve in fiduciary roles for perhaps liability purposes, perhaps their insurance won't allow them, whatever the situation might be. The family advisor role will allow these advisors to become part of the ongoing document and family control. And you can see there on the next 2 pages, it's been codified by law. There's 4 specific responsibilities that have been outlined in the law that the family advisor has the ability to do. And most importantly, our clients like that the family advisor actually can remove and appoint new trustees. If they no longer want to work with Bridgeford as an administrative trustee, or the investment trustee, or the distribution trustee. There's many mechanisms to remove those parties, and the family advisor is one of them, among many other powers that have been given here. I think how we as a corporate trustee envision the family advisor helping the situation is that we can consult with a family advisor on various situations. And when we look at families and their trusted circle, typically those TPAs, attorneys, and investment advisors are in that circle. So that provides us some additional comfort when we have somebody that's in that circle that we can go to help make a decision.
Absolutely. It's exciting. It's another example of modern trust law, I think, at its finest. It's a direct result in a response to what advisors and wealthy families have been looking for, and it's exciting. Decanting. This is a sort of a final trust law that we want to quickly review. A lot of people understand the concept because it's not old, and in fact, it was the first decanting statute was passed in New York State many years ago. And essentially, what it does is it's a distribution of assets into a new trust. If you think of wine, it's very much like wine. You pour wine into a decanter. It's essentially a new vehicle. It's a new holder of that wine, and this is exactly what we're doing here with decanting. And so the question is, why does this matter? Well, remember I said earlier, the idea of an irrevocable trust is so different than it used to be. Decanting is another reason for it. We can easily change pretty substantially a trust that is old and tired and doesn't perform the way we want it to perform based on changes in generational activity. And the key here, is you don't have to go to court. There's no reason to go to court to do this, and we see it used all the time. And on the screen here, there's what you can use this for. To transfer situs, we use it all the time for transferring situs. Correct drafting errors, change administrative terms, change trustees, and it's a very simple process. And not all states are created equally from that perspective. There's only a there's more than a handful of states that have them. But there's a chart, another again by Steve Oceans, that sort of compares these statutes and looks at an objective rubric here as to determining which is the best decanting statute. And it's really, again, using that dirty word again, liberal. South Dakota is by far the most liberal decanting statute, which a lot of advisors really, really like to see. And so we are excited about the ability to use that decanting statute in conjunction with trust protectors, in conjunction with family advisors, in conjunction with directed trust statutes, and the flexibility of directed trusts, and all of the modern trust laws we've talked about. This has changed the landscape. I keep saying this, but it's absolutely true. Irrevocable trusts don't mean what they used to mean. So what we'd like to do is transition to taking a look at all of these concepts very quickly, and then talk about how these all combine to draw international clients into the United States. This chart that we produced is well cited, well researched, and goes through each of the topics and compares the the states of the United States that are considered to have top-tier trust jurisdiction powers. And sort of definitively, the gray areas show which areas where South Dakota sort of ascends. Now, the point of this chart isn't, again, and the point of this presentation isn't necessarily to argue that South Dakota is where it should be. The important thing, in my view, in our view, is that you select the jurisdiction that best serves the client, that is better than the jurisdiction that you may be in, and know that there are options to go to a better trust jurisdiction, and know that even within the top tier trust jurisdictions, like the ones mentioned here, there's a difference. The nuances are there, and the devil's in the details, as they say. And to take a close look at this chart to say, well, look, if your client is worried about asset protection, if your client is worried about privacy, and that's what's driving a lot of the planning, well, this is pretty clear and objectively demonstrated that there is a state that happens to have a little stronger law in that respect. But all of this transitions into where we want to end, which is, we say coming to America. There was a movie there was a movie about that. But the reality is, for so many reasons, international families are coming to the United States. I know so many of you on this call. I see who's on the call now. You work in international space, and kids come here to be educated. They get married. They marry U.S. citizens. They have businesses here. We know that's what drives people to the United States. They have a need for a U.S. trust solution. What is somewhat newer, and I think actually pretty exciting, is the other new reasons why people are coming to the United States. Unbelievably, the United States has been considered to be a tax and privacy haven by Bloomberg magazine and other advisors around the world. And you wonder, and we all kind of scratch our heads because we've been advising clients for a long time. Well, how did that happen? How did all of a sudden the United States become a domestic asset protection haven? Well, I'll tell you how it happened, and I'll tell you what's being written in the literature. The Panama Papers happened. That's shook a lot of people up and has driven a lot of people out of jurisdictions like Panama. Whether it's fair or not, whether it's appropriate or not, people see information being precarious in those jurisdictions. The Common Reporting Standard is probably by far one of the biggest reasons why we're hearing people are concerned about their privacy. Common Reporting Standard, or CRS, is the international version of FATCA. A lot of you know and have heard of it. It was passed in 2014. Over 100 jurisdictions around the world have signed off on it. Jurisdictions that were once considered privacy havens like Nevis, Cayman Islands, Switzerland, Bahamas, and Panama, and 95 others. The reason why this is so important is those seeking privacy are not going to get the privacy they used to get out of those jurisdictions because CRS commands and demands the sharing of information among nations. This just doesn't apply to people with bad intentions. And in fact, I would argue that most people who are concerned about the CRS and most of these wealthy families are not trying to hide anything. They're trying to protect their families because unlike what happens in the United States, if a family in Colombia gets discovered as having billions of dollars, their kids are stolen and kidnapped. And there are very real, non-nefarious reasons for wanting to be in the United States, in addition to the ones at the top of the page. And so we're seeing that the CRS is driving so much concern around privacy. And so when you combine the privacy issue with the fact that these jurisdictions like Panama, Nevis, Cayman Islands, and others that have been an international offshore trust or asset protection jurisdiction, when you combine all of these forces, they're less palatable, and it's excuse me, culminating to a point where all of this discussion today, all of these new modern trust laws have culminated to create an extremely attractive alternative for international families in Latin America and Europe. And, my partners and I have been around the world having conversations with trust companies and investment advisors. We've been to Switzerland and we've talked to the banks in Geneva and that are very worried about the fact that their privacy laws have been stripped away. And so the question is, will the United States ever sign off on CRS? We don't know. There's the debate right now. It really is immaterial because the amount of activity and activity coming to the United States because of it is extremely overwhelming, and it's frankly an opportunity. I mean, so many of us on this call are see this happening, whether we like it or not. It's happening. It's coming, as Jessica has said several times. Ready or not, here it comes. We need to be prepared to understand how to do KYC, know your customer, and background checks. We need to have to understand how these laws impact and integrate with international tax laws. And it applies to lawyers on this call, accountants on this call, investment managers. All of us are going to be faced with this question, and we can't put our head in the sand and say, well, I don't want this to be a part of my practice. It's going to be a part of your practice, and in fact, it's a tremendous opportunity, as we see it, to position yourselves to be able to handle all of this. So that's sort of the conclusion, which was how we've begun. I guess we'll end as we began, which is to say it's a whole new world in the trust space. Jessica and I at Bridgeford and other professionals in our space are seeing these modern trust laws radically change traditional notions of how to plan for families. The control that's delivered back to families is unlike any other time in the United States, and that is what's attracting, in addition to the other factors that we've mentioned, so many people to the United States. We would love to answer any questions that you would have at this point. We are hoping that this was valuable. I'm sure you've sensed the passion that both Jessica and I have around these modern trust laws, particularly out of South Dakota. Bridgeford Trust Company is happy to answer any questions and to serve in any way that we can, and we appreciate that so many of you from around the world participated.
Thank you once again for joining us for this presentation produced by McConley and Asbury. We hope you join us for our upcoming events. You can stay up to date with our news and learn more about our upcoming events by visiting us at www.macpas.com. Thanks again and have a great day.